Let's take a look back at another clip of defense counsel's closing argument talking about Ethan being a master manipulator.
It's obvious from the evidence in trial, and you may find it to be a reasonable doubt, that the Crumbley son was a skilled manipulator and they didn't realize it. He's not sick. He doesn't have a mental illness. He's had no history of hallucinations. He has never shown his parents signs of mental illness. He certainly never showed signs of mental illness wanting to get a gun. No parent would purchase a weapon if they believed their child had mental illnesses. And these are people that had 2 other guns in the house for months where nothing ever happened with those guns. They had no reason to believe that somehow this 3rd gun was the thing that was going to make the difference.
We need to back the truck up here, don't we? Jamie White, I'm listening to counsel. And did we all watch the same trial? Because we heard evidence about the child hallucinating months before the massacre was carried out. He's seeing demons in his kitchen. The demons are throwing dishes. He's texting mom and dad. I mean, so we have an electronic record of those communications. It's all case evidence that the child was experiencing hallucinations, asking for help, asking his parents to take him to a doctor because the thoughts wouldn't stop. And she said there was no evidence he was having mental health problems. Jamie, I mean, is this, I am just, I don't have the words today watching defense counsel. I don't. Your thoughts on what the jury might be thinking having taken in that evidence?
Well, I think the jury is going to feel this the same way you do to some extent. I know Shannon Smith. We've worked on the opposite side of trials before. I think the point that she's trying to make, at least outside of even your clip, is that as parents, we all have, at least I have with 4 children, have had experiences where children do and say things and act in certain ways. And when it comes to involuntary manslaughter, it's important to keep in mind, and I'm not defending what you just described, Julie, but objectively speaking, it's important to keep in mind that the standard is not that they knew this child was going to act in a certain behavior. Is it foreseeable? And, I think that is a question of fact that the jury is going to have a difficult time dealing with. But so here's the thing. There's no question, Julie, that the parents here are beyond negligent, right? But we have different protocols and systems in Michigan to deal with parents that are unable to take care of their children, whether that's Child Protective Services or the juvenile court system. There were opportunities. The school had notification of these problems, and as mandatory reporters, they called the parents, but they took no further action. So I don't disagree with you. These 4 children should be alive today. There was certainly an opportunity to intervene in what a lot of people believe was foreseeable behavior. But I think Ms. Smith does bring out a legitimate point when she shows that, as parents, she included herself, which a lot of people have taken exception with, but I will give her some courageous points for that any of us could find ourselves in this position because you want to believe your children, you want to love your children. At what point do we hold people legally accountable to a standard beyond a reasonable doubt under these facts and circumstances?